Welcome to our video series, Data Act Unlocked. In this series, we provide a concise overview of the most important provisions of the EU Data Act. This episode is about data contract law. We take a look at the provisions of the EU Data Act regarding unfair contract terms in the B2B sector. Article 13 of the Data Act contains a new terms and conditions law for data between companies. According to these rules, contractual terms imposed unilaterally on another company shall not be binding on that company if they are unfair. However, the new rules on general terms and conditions only apply if the contractual terms are supplied by one company and the other company has not been able to influence their content despite an attempt to negotiate them. These rules apply to contractual terms concerning data access and data use on the one hand, and to liability and remedies in the event of a breach or termination of data-related obligations on the other. The EU Data Act stipulates that, in general, contract terms are unfair if their use deviates from good commercial practice or violates the principle of good faith and fair dealing. In order to ensure legal certainty, the EU Data Act introduces a blacklist of contract terms that are always considered unfair. The following are particularly abusive: provisions on complete exclusion of liability or limitation of liability in cases of intent and gross negligence, regulations on the exclusion of warranty rights or legal positions in the event of breaches of contractual obligations, regulations that provide for a unilateral right to determine benefits. Additionally, a grey list of contract terms that are presumed to be unfair has also been introduced. Such unfair terms include, in particular, regulations according to which the user of the clause may use the business partner's data even though this conflicts with the legitimate interests of the other contracting party. Prohibitions that prevent the contractual partner from using the data provided or generated during the term of the contract. Regulations that prevent the contractual partner from requesting their data after termination of the contract. To wrap up, here are the key takeaways from this episode of our new series, Data Act Unlocked. The EU Data Act introduces new terms and conditions law between companies. Unfair, unilaterally imposed contractual terms are not binding on the disadvantaged party. This applies to clauses on data access, data use, liability, and legal remedies. There is a blacklist of clauses that are always unfair and a grey list of clauses that are suspected of being unfair. We're glad to have you following our series Data Act Unlocked. For more insights, check out #CMS Data Law or visit our website.